And good afternoon, everybody, and welcome to our latest version of the Inside the Trusted Workplace series here at Verimark. For those of you that have not met me before, my name is David Morgan. I'm the Managing Director of the Whistleblower Technology Solution line here at Verimark, and I will be the host of the discussion today. And I'm very excited to say that we've got a really fantastic guest speaker on in Tony Morris. For those of you that don't know who Tony is, Tony has been in the industry of investigations, workplace health and safety, and psychosocial risk for over 30 years. He's a leading expert in this field, with a career span in law enforcement, prosecution, consulting, and law firms. He's worked at some of the biggest law firms in Australia, such as Ashurst. He's also worked at Deloitte and was a partner there for a period of time. He also founded a company called the Briefing Group and was the founder and director of that business for over 13 years before he took that company into Deloitte. And in more recent times, he has founded a company called Safe TM, which I understand he's the director of, and is now doing some work that he's very passionate about, still in the workplace health and safety and psychosocial space. But I think, as Tony has said to me a couple of times, I can now pick and choose the types of engagements that I want to do. And he does some very interesting training work which focuses on mock courtrooms. So when we have to give evidence, and I know Tony's been in the box, I've been in the box many times myself. If we can be better prepared for that, that is certainly, I think, a very valuable sort of form of training. And I know, from what I've heard in the market about this form of training, it's very well regarded. So very widely recognised in Australia as a thought leader in this space, and we're very lucky to have him as our latest guest presenter on our Workplace Trust series today. The important thing to remember also, in addition to Tony's expertise, is the overlap here between this area, which Tony's going to talk to us about, and the whistleblowing area that, of course, we're focusing on so strongly with the technology that we're building here at Verimark. And that, the culture and how we create strong safety cultures, and the governance frameworks that support effective whistleblowing is really important from an early intervention perspective, when we're talking about workplace harm and trying to minimize that inside the workplace. So there's some really strong synergies here between what we're doing at Verimark and trying to develop best-in-class technology to help people report concerns early, with the expertise that Tony has in this space. Welcome, Tony. How are
Thanks
you?
very much, David. Yeah, I'm very well, thank you. Geez, 30 plus years makes me sound old, but I'm very well, thank you. Great to be here.
It's great to have you here. And I know when we were sort of planning out this session a few weeks ago, you felt that there was some case studies that you may want to sort of revisit and perhaps bring onto the session with us here at Verimark. Have you decided on anything? I'm presuming you have.
Yeah,
Have you got one ready for us?
I certainly do, because you asked me to, and I certainly do, David. I've chosen a case that it's proceeded over many years now, or the actual risk itself, the psychosocial risk, was around in 2015. It culminated in a suicide of a person in 2018, and it followed a criminal conviction under the work health and safety laws for failing to manage psychosocial risk in 2023. So that's a lot of years, and that's a lot of time for that to get to court. But I think it's a really good example, and I've chosen this case carefully, because it involves an intersection of psychosocial hazards which created the psychosocial risk. And I think, therefore, it's a really good case study to talk about. The other thing is, I think it's relevant, and I've mentioned the word suicide, to give a warning to any listeners that we are talking about some serious things here, and some of this may jolt some people. So just beware that what we're talking about is suicide. But these cases are really important to talk about, I think. The other thing I'll say, Dave, and I think you sort of touched upon it, is that I don't have experience in whistleblowing, but there's a clear intersection between what I do, which is a psychosocial risk management component, and in particular with the work health and safety lens. And a breach of work health and safety law is a criminal offence against a corporation or an individual, whether it be an officer or a worker who is prosecuted. That is my experience, and that's the lens through which I'll talk. In my travels in safety, it has intersected with whistleblowing. And I think, and I'll ask you to ask me questions throughout about the intersection with whistleblowing, because I know that's your particular area. So whenever you're ready, I'm happy to introduce the case and ask that you ask me any questions along the way that your listeners may be interested in.
Yeah, no, sounds brilliant, and yeah, a really nice introduction. Certainly, listening to what you said there, the time frames, and how we know how difficult these things can be if we're caught up in it as perhaps a victim or somebody that's experiencing, bad behaviour inside the workplace, and then of course the legal process that we know can take such a long period of time after that as
Yeah.
well. That's certainly one thing that sort of stood out to me when you did that introduction. The second thing, yeah, that intersection piece with whistleblowing and what we know about the legal protections, not just around whistleblowing, but you alluded to it there with workplace health and safety, those protections to people under the Workplace Health and Safety Act.
Yes.
So the different forms of protections for different people depending on
There
the types
is.
of businesses. And I definitely want to talk to you a little bit about that during this session as well. But no, I'm really interested in hearing more about this case study. So I'll get back to
Great.
you.
So any listener can look at this case on the internet. It's WorkSafe Victoria versus Court Services Victoria. The case, it was a matter where by this point in time, 2023, Court Services Victoria pleaded guilty to the allegation that it failed to manage psychosocial risk, an offence under the Occupational Health and Safety Act in Victoria. At that time, it pleaded guilty. And I'll go straight to the end of the book and say that the conviction and penalty was for $380,000 fine. Court Services Victoria were fined. Interestingly, a judge of Court Services Victoria found Court Services Victoria guilty. So the judge who was sitting in a position of passing judgment actually convicted the organisation that he was working at. Mind you, every judge and every magistrate in any jurisdiction around Australia, including Victoria, they're not employed by Court Services Victoria. They are appointed by the Attorney General and sit there as an independent. They could be more independent. It's probably in our jurisdiction in our world. Judges are very, very independent. So whilst not employed, they were working at Court Services Victoria at the time. So that's rather ironic, I find, but really important that no one's outside the law. The particular case concerns a matter, as I mentioned, which occurred, the facts of which started in 2015 and proceeded throughout 2018. It involved, the particular matter came to the attention of the safety regulator, WorkSafe Victoria, when there was a suicide of a senior lawyer. Her name was Jessica Wilby. So all of what I'm talking about is on public record, by the way, Dave, and that's really important because none of this is confidential. But Jessica was the second in charge lawyer at the Melbourne Coroner's Court. So Coroner's Court is a jurisdiction within Court Services Victoria, which is, if you look at all the other legal areas within court services, they're much bigger. Coroner's Court is a small specialist jurisdiction within the state of Victoria, doing coronial inquests and preparing for those inquests and doing that. So Jessica, the person concerned that gave rise to this issue, she was the second in charge lawyer there at Melbourne Coroner's Court. And she had a very important role. She had a number of team reporting to her. She applied for and received, well, she got the job of the chief lawyer. She was successful in getting that job, which was the top lawyer in the Coroner's Court in Melbourne. At the time that had happened, she was informed that it'll take a couple of weeks for court services and the coroner's court to appoint a new lawyer to take on her second in charge lawyer role. And they asked her to continue doing that previous role and take on the new role, which had about 20 people in the team. But she had more reports, she had more work to do. She was to do her existing job as second in charge plus the new job. They said it'd only take a couple of weeks to replace in that position. Some 8 months later, they still had not replaced that position. Like many psychosocial risk matters starting to come through the court, what this case involved was a number of psychosocial hazards which led to the risk, and not just one. For instance, obviously, from what I just said, there was a lot of work demands, significant work demands upon Jessica and the team, but because she had this role, she was working back every night. She was working pretty much every weekend. She was a workaholic, if you like. And she was also a known perfectionist. She was a perfectionist, and this is what a number of investigations said about the matter. And there was a coronial inquest done, by the way, which was a separate sort of inquest, which I'll talk about a little bit later. But there are other hazards, psychosocial hazards at play here, David, in particular, role clarity. It wasn't clear with respect to roles, and lots of people were jumping in to do other people's work. There was change management occurring within the jurisdiction. There was allegations of bullying and harassment and conflicts within the workplace between the people working at the Coroner's Court in Melbourne. Also, there is always traumatic material for people in that jurisdiction to read, to see, and involving a lot of death and mayhem. Of course, it's just the nature of that jurisdiction, which people understand when they go into it. But when that's coupled with all these other issues, bullying, harassment, role clarity, job demands, and what was happening based on the facts was that Jessica simply wasn't sleeping. She was suffering from insomnia. There was no previous history of mental illness. Jessica was 45 years of age, and she took her own life in September of 2018 it was. Now, between that time, 2018 to 2023, was the conviction in court that Court Services Victoria pleaded guilty to in this particular matter. When you think of work health and safety, there is a danger when you think about the actual incident and just focus on the suicide, because that does not create the offence. What WorkSafe Victoria would have had to have done, and they did obviously, is wind the clock back and look at the systemic issues contributing to the risk and whether or not Court Services Victoria were proactively managing the risk to health and safety. The evidence that they gathered indicated they had not, that they hadn't adequately done a risk assessment. They didn't have adequate controls in place, that Jessica was not the only person subject to work demands and bullying, harassment, that others were, and others had gone off sick and never come back, and others have gone off on leave and stress in that particular jurisdiction, Coroner's Court. So the actual offence is not for the suicide. The suicide, if you like, of Jessica brought this matter to the attention of the safety regulator, and then they come in to investigate and wind the clock back to have a look at whether or not there was adequate risk management. Obviously, they thought that there wasn't. But what had happened before the WorkSafe Victoria prosecution was those in charge decided to get a coronial inquest conducted. And of course, it couldn't be conducted in Victoria because that's where they worked. So a New South Wales coroner conducted an investigation. And the outcome of that was that this area was a toxic workplace, and I'm quoting toxic workplace, where there was issues of work demands, role clarity issues, job control, change management, organisational justice, and traumatic material, and bullying and harassment. So there was an intersection of about 7 or so psychosocial hazards. And I think that's a really good case study to consider, because if there is a death in these matters, often there is a coronial inquest before the criminal work health and safety prosecution. And so that will settle. And of course, the coronial inquest has different objectives and different purposes, whereas the work health and safety criminal prosecution is there to, on behalf of the public, to prosecute and punish any offenders that have failed to manage health and safety risk. And it's a separate objective, a separate purpose, as well as it is to act as a general deterrent to anyone else, whether it be in the industry of law or legal or any other workplace for that matter. So in this particular case, whilst it's a very sad case, it's one to talk about, because I think that any workplace that has different divisions is quite large. You know, how does it know what's happening on in different jurisdictions, in different divisions, in different areas of the business when you're not there all the time? And I think it's a really good one to talk about. And I'm sure you've got lots of questions from what I just said.
I have no, I don't know where to start. No, look, really interesting introduction to the case. There's a few things that sort of stood out for me. You talk about those number of hazards and the poor behaviour like bullying or harassment, but that interplay then with how the role perhaps is designed for the person or not well designed, the pressure on the person, taking that, having that dual role and having so many staff and having it for such a long period of time. I mean, that must have been absolutely, I mean, yes, it sounds like the lady had good work ethic and was a very confident sort of operator, but at the same time, I mean, those additional demands clearly had a significant impact on her. And then change management, that's an interesting piece. And when I then sort of look at that intersection with whistleblowing, and I've obviously done my homework, Tony, and I've had a look at the case. And what I thought was really interesting when we talk about that intersection was some of the descriptions around culture inside the organisation during that time frame you've talked about. So things like culture of silence, so people not feeling that they know where to go or know how do I report the problems. And then it talks a lot about, in terms of the culture, power imbalances, because some of the worst, people in terms of their behaviours were very senior people, whether it be lawyers, barristers or judges. Again, people felt threatened by that and didn't feel that they could speak their mind or challenge these behaviours. That's what I found really interesting in that intersection between how things are set up, but then the impact that has then on that collective behaviour and culture, therefore.
Absolutely. And it's a very challenging dynamic in a court and a legal environment, just like you indicated there, David. And one of the things I read about this case, which came out in the coronial inquest New South Wales coroner had done, was that Jessica, the deceased, had confided in her sister. And one of the things that, her sister was trying to encourage her just before she committed suicide, to go and see doctors and to report these matters. But she didn't want to. And the reason why she didn't want to is because her goal, her sole goal for going in there, was to become a judicial officer one day, to become a judge one day.
Yeah.
And she felt, and she was probably right in this feeling, that if she were to report this, if she were to say that she couldn't cope, if she were to go off on sick for an extended period, and she needed a rest, right? She needed to get over this insomnia and stop working all these crazy hours. If she were to do that, she knew, in her opinion, that she would never get to become a judge. And that was the only reason why she put herself through all of this. And I wonder, that's an analogy to why a lot of people may not wish to raise issues, because they feel that it will affect their career. And you know
Yeah.
what? They're probably right in some circumstances. So we have to, whatever systems we think about, whether it be work health and safety or whistleblowing, we have to be very well aware of that, that there are dynamics and there are power issues at play in these large organisations that have an effect on whether or not people report.
Yeah, yeah, absolutely. And the the ability for the person to unload their
Yeah,
problems with the right people, because of, yeah, I'm sure to a degree she may have been talking with friends or family, outside the workplace, but there's, in my experience, there's nothing better than empathy with colleagues or with a supervisor, a good
yeah,
supervisor, at a point in time that can reassure and really bring you back down to earth inside the workplace. And that was
absolutely.
clearly missing, I think, in this case, from what I've read.
From what I've read about it, and I've read a lot about it, that's the case in this particular instance as well. And when an independent coroner from a separate state says that, in his opinion, it was a toxic workplace and a toxic culture, there's major issues there, and there's a lot that obviously over a period of time as well that leads to that conclusion. And that's the other thing I think, and it's worthy of a bigger discussion from you and me, is
Mm.
this occurred over 2 years. Jessica wasn't the only person subject to this. At what point, it shouldn't all be on Jessica either. At what point should have the organisation, Court Services Victoria, which is much bigger than just a coroner's court,
Yeah,
at what point ought they have known and should have known about this and should have been much more proactive? Where's the risk assessment? Where's the controls? Where's the measuring and monitoring as
yeah,
to these controls to minimise the risk if they were working? And the case was that Court Services Victoria were not aware. The next question is, well, why weren't they? And the court was obviously of the opinion that they ought to have been aware and they ought to have done something, and that's why they were convicted.
yeah,
And Court Service Victoria would have accepted that, and that's why they pleaded guilty. So, so it becomes. I think the challenge here is there are so many ways and avenues by which to report a matter such as this. This is such a significant matter because not only did it lead to this prosecution, but one of the things that I raised about this case was that there was actually an independent um, inquiry and review done of sexual harassment in the Victorian court system. This particular case, along with a few other cases, was the reason why that inquiry was conducted, and a significant review report provided in 2020 called the Soke report, SZOKE report. Helen Soke is a barrister and an independent who provided that review report, and there was a lot of recommendations for, there was 20 in fact, for continual improvement across the legal system in Victoria. So it just happened to be that the crystallisation, the worst thing that could happen, was in the coroner's court in Melbourne. But this risk existed throughout the legal fraternity in Victoria. And I'll guarantee you it won't just be Victoria, it'll be other states and territories that have this risk in their legal jurisdictions because there's the same power play
mm.
in each of them. So there's a lot there to unpack about what I just said, but interested in your thoughts on that.
Yeah. Well, I have done quite a few sexual harassment investigations, over the years in my investigative work, and yeah, when I listen to you and I reflect on the work that I've done in this space, the people, the victims of sexual harassment have, yeah, been far more junior than the perpetrators that I've also been investigating. And it's it's a sad story, but unfortunately, sexual harassment does have very high levels of underreporting.
Mm,
People don't come forward and speak up about these types of matters. I think there is progress being made,
yeah,
because of some of the regulatory changes that have happened in this country over the last sort of 2 to 3 years. But there is still a long way to go, and I think some of these sectors that we're talking about here, which are still very old school and traditional with their thinking, and the people in those leadership roles, heavily sort of male orientated.
Mm.
There is still a lot of it that goes on.
Yeah, absolutely. And the other issue for me, David, which is important for all the listeners to really understand, is that there are different jurisdictions and different purposes of law at play when it comes to psychosocial risk. And as I said at the start, my experience is the criminal work health and safety jurisdiction. But people need to understand that there is a difference between that jurisdiction that I'm talking about and the Fair Work Commission, for instance, where a person might go to the Fair Work Commission because they feel that they're being bullied or harassed or there's unfairness at work. And that's a separate case in regards to that particular person making the complaint. There's also industrial laws and human resources type legislation where HR really have a policy creation and a response focus to these types of matters. So their lens is very different to the proactive risk management work health and safety lens. Theirs is more a response for an individual following a report that might, whether it comes through the whistleblowing avenue or some other avenue to HR, they'll respond in that way. Now, the work health and safety lens, it notes that an incident's happened, but it's not the focus. The focus for work health and safety is on the organisation's risk management, whether that was there or not, whether or not a risk assessment took place, whether or not people were adequately consulted, that is the working group, whether or not the hierarchy of controls were considered when it comes to minimising the risk, and whether or not there's good reporting to measure and monitor those high risk controls in psychosocial risk. So whenever anyone's reading a case, they need to understand in what context, what case is this, what jurisdiction is it, and what's the purpose of that jurisdiction.
Yeah, and I think that's a really, again, another strong sort of interconnection with whistleblowing. I talk about this a lot, you know, at Verimark and with our partners in our sort of thought leadership material around do not look at whistleblowing in the modern world as a compliance function or a compliance program. It is a lot broader than that. It is governance in my sort of professional view. We're talking about not just the whistleblower laws. We're also talking about how relationships, you know, play out inside the workplace and how comfortable people feeling at, you know, raising concerns and telling not just good news but bad news. There's also a process and risk element to whistleblowing as well, in terms of how, you know, how well we promote it, how well we design it, how, you know, how well understood it is. We know with whistleblowing, and which again, you know, interconnects back to your work, that there can be a broad set of types of risks that people blow the whistle on. It is not just fraud and financial crime. People can raise concerns through our channels, you know, at all types of issues, and they can come through different parts of the organisation as well. So, yeah, we're very aligned with your thinking in that workplace health and safety space around it should be at an organisational view. It should be sort of starting at the board, and it should cascade down sort of accordingly from there.
Yeah, which is where I think, and I'm interested in your perspective. I have a perspective from work health and safety lens that the whistleblowing avenue of reporting is very important for work health and safety when, in circumstances like this, there is a systemic failure that strikes at the heart of leadership and the culture of the organisation. For example, we've seen a lot of cases where CEOs have been brought down because of allegations of sexual harassment or sexual assault. And these are work health and safety matters. They're also, you know, a HR response matter. They could also go to the Fair Work Commission. But for me, you know, because there is that added protection in the whistleblowing legislation, that this is where people should consider using that avenue. There is protection under the Work Health and Safety Act that says this, that no person ought to suffer to their position, their employment position, through raising a health and safety issue, whether that be a complaint. So that is the law. It's the law across Australia. It's in all the jurisdictions. However, it's something, if someone's challenging that and says, I was sacked because I raised a work health and safety matter, and I'm taking that matter to the Fair Work Commission now, there has to be a causal nexus proven between the decision to injure that person's employment or sack them or whatever, and the fact that they raised a work health and safety matter. So there's issues there. And this is why I think it's good that the whistleblowing avenue of reporting can be used as another added layer of protection. Am I right in thinking that?
Yeah, absolutely. And when I listen to you speak there, and we think about the Corporations Act here in Australia for the whistleblower protection laws, they have tried to broaden the protection of the person in terms of the types of offences that can be captured under those protections within the Act, which took place in 2019. So it's not as narrow as it is in some other jurisdictions, where you may have a list of particular offences that are described within the Act, where here we have got a broader definition around that improper state of affairs, which sort of goes to, is there a systemic problem inside the workplace, which is designed to try and encourage more people to come forward and get protections.
Right.
And when you look at some of the other jurisdictions around the world, sexual harassment is starting to come into whistleblower regulations. So in the UK, for example, it is now a listed offence under the Public Interest Disclosure Act over there, and there are other laws as well, which are increasing the burden on, or the responsibility on the employer to do more to deal with these things earlier. I think, yes, we do want whistleblowing, and we do want that safe reporting channel to be in place for people to be able to raise sexual harassment concerns. And what is important in that sort of context is making sure that the organisation promotes that in the right way and designs it in the right way so that people feel safe, because it's a very different type of offence, of course, to something more fraud or financial crime related because of the impact on the victim. So that's where I think there's a lot of work still to be done, is in that understanding from boards and senior executives around what these practical remedies look like when it comes to reporting, particularly third-party reporting, which is valuable because of the safety associated with it, typically the independence. And with the technology, you can then put a layer around that, in addition to that, around anonymity and security as well for the person. And that's what I think there's still, yes, we're making, I think we're making some good steps in terms of regulatory changes, but there's still quite a few steps to go from a practical sort of design and implementation point of view.
Yeah, that makes sense, because one of the things I'm thinking that we don't want the whistleblowing avenue of reporting to be the default reporting for all psychosocial hazards. Absolutely not. It should only be used, in my opinion, where there's systemic, cultural, significant issues affecting the organisation that it needs to be raised in that manner, and in circumstances where the person or persons reporting feel that they need that extra layer of protection that is afforded by the law there. Whereas if there is a psychosocial risk because hazards aren't properly being managed, they ought to be raised through the organisation in the same way that you'd raise any other health and safety hazard that's not being properly managed. You report it directly. You don't even have to report like who it is making the report, just that in this area of the business, in this division, this hazard's at play, people are at risk. Let's get the health and safety team on managing that risk better. Keep it a systemic organisational focus, and no one needs to fear about their job or be worried about it. And that's why I feel that it's better and quicker if you don't go through whistleblowing, but whistleblowing needs to be there if you got an issue such as the case that we're talking about, where it was just a toxic culture and a toxic workplace. for me, the whistleblowing avenue would have been the proper and the right way to raise an issue in that case in Coroner's Court in Melbourne back in the day, 2015 to 2018. But what I don't espouse is that every psychosocial hazard was reported through that mechanism, because it's not the right way to report it. You can't get onto it quick enough either if you do it
No,
that way.
I agree, and because a lot of matters of a bullying or harassment nature, which as you've described, are psychosocial risks. They on their own don't perhaps tell a full picture, and so therefore what happens is that the scope of the assessment or the subsequent investigation will become very narrow and sometimes over the top for the level of
Yes.
bad behavior that may or may not be occurring. And so, a sledgehammer is taken to crack a nut, and that makes the workplace potentially worse. And I've certainly seen that sort of inside the workplace, quite a few times, trying to get that balance right. And you're right. I think the early intervention piece. If we think about role design, if we think about things like how do we structure the organisation well, so that people can report up or sideways, that we recruit well, and we do good due diligence on our staff, bring them in to make sure that they are a good cultural fit for the role and for the business. That's going to reduce the likelihood of something like this happening again.
Yeah, it does. And you raise another good point that triggers something in me, and that is the investigation. So important, as we both know, but depending upon the avenue of the way that a report is made, e.g. whistleblowing, work health and safety, or a grievance to HR, will often lead to the way and the purpose of an investigation that may or may not follow.
Yeah.
So for me, before and when I do any investigation, I'm sure you'd be the same, you would make very clear what is the purpose for this investigation. For what purposes or purpose are we investigating it for? Is it just for a whistleblowing matter? Is it just for a work health and safety? Is it for HR? Is it for fair work complaint that may come up? Or it might be all of the above. What's really important is that just because a report goes through one avenue doesn't mean you restrict the investigation to that avenue only. The organisation needs to be smart enough to work together to share appropriate information while still protecting privacy, and also consider for what purposes do we investigate this and what facts do we need to find out, because a work health and safety investigation is very different to a HR and industrial relations one. And I could see it could be very different to a whistleblowing one as well. So to make the purpose really clear, and I think the outcome of what I'm saying is the importance that HR needs to work with employee relations and work health and safety and the risk areas of the business to work together on this, because otherwise, if they work in silos, information and opportunity would be lost.
Yeah, and that part of the investigation where you are assessing the complaints and trying to determine what the avenue might be, what the purpose might be, who might be the right person or expert to conduct the investigation, that often isn't done well.
No.
My experience as an advisor, when I've come in, that hasn't always been done well, because some of those stakeholders are not good at collaborating or working well with those other people across the organisation in those different functions you've described, and therefore they don't have the full picture, and that leads to wrong decision making around what they do about it and how they design the scope and purpose of the matter. So I've seen that quite a few times, and often us as the third party, we just come in late in the day when things are can be quite bad, having to look again at the purpose or bring new information to the client because of what wasn't done perhaps earlier in the piece that should have been done.
Definitely. I also find another issue in some organisations and large ones often is a clarity of who is the decision maker and for what decisions. For instance, who makes the decision within an organisation to have an external investigator appointed, or whether or not they have an internal one, and who makes the decision once the investigation is completed and recommendations are made and the facts are there as to what ought to happen, whether that be with an individual's employment, whether that be to do with the work health and safety management system improvements, or any other decision that needs to be made. Often I find that it's not clear within an organisation who makes these decisions, and therefore no decisions made, or there might be argument in a group of executives about what ought to be done. And I think it's really important that organisations need to think proactively about who makes what decision and when. Do you find that as well? Have you found that?
Yeah. I mean, it's a really interesting sort of observation, and particularly with the matters that we're talking about, when they're, typically it's a problem with your staff that, in some degree of severity, depending on where they've caught it, how early or how late. And, yes, some of those functions are independent and should be looking at this problem or series of problems objectively, but that isn't necessarily how it plays out in practice. It becomes a bit of vested interest and protection of people's patch, and which can result in these arguments and lockdowns of information and subsequently poor decision making around what they do next and how they handle things.
Absolutely. So look, for me, I mean, some of the listeners might be wondering, what are my tips for when it comes to, from the work health and safety lens, proactively managing the risk? I think the important thing is, and I might just, if it's appropriate, share my screen of the various different psychosocial hazards that exist, because it's not just bullying and harassment. And if that's appropriate, I will share my screen, David.
Yeah, please do.
Can you see that on screen?
Yes, I can see that.
Right, so this is just one slide that I wanted to show, and those listeners that can also see visual, I'd recommend having a look at this. These are the psychosocial hazards that Safe Work Australia, the policy-making body in Australia for work health and safety, have indicated. And they're not limited to these, but these are the key psychosocial hazards that they've indicated that we need to proactively manage. I have put them into 4 quadrants, from the social type of hazards to the environment to governance and work design matters. And in the social area, from if you imagine a clock here at 12 o'clock, between 1 and 3 o'clock, there's a normal HR type hazards: violence and aggression, bullying, harassment, poor workplace relationships, poor support, conflicts at work. Some of the things that we're talking about in that case appear there, and I call them the social hazards. A lot of people don't think about the environment types of hazards, traumatic events or material, and a lot of workers in different industries are exposed to that. The physical environment is the hot and cold environment, or anything about the environment that could cause a hazard to person's psychosocial risk there. Remote or isolated work, people that have to work like that. Then we've got the governance issues, change management, which is, to me, probably the biggest psychosocial hazard raising its head right now, because every organisation is undergoing change. AI is a good example of that, but other changes as well. Poor organisational justice or poor reward or recognition. And then you've got the work design issues, job demands, role clarity, and job control. So the reason why I popped those up, and I'll stop sharing now, is because the first thing I consider if I was an organisation or a leader is which of those hazards are critical for us, which of those hazards raise its head in our white collar or blue collar environment, or perhaps as I've been working with a client that has both white collar and blue collar, and each of their psychosocial hazards and risks are different in a blue collar environment to the white collar. So the next question is, where's your risk assessment? Have you adequately assessed the risk
Yeah.
that these hazards entail? Have you consulted with the appropriate working groups that are exposed to these hazards? And that's usually through a committee, but not all clients or employers have committees. They might have another way to consult, but have you consulted and communicated? Have you used the hierarchy of controls when you look at controls to minimize the risk? That's the next thing. And finally, what reporting is going to officers about the control environment and whether or not it's working? Now, yeah.
Yeah, just listening to you, fascinated. How do you find those some of those internal dynamics then from the work that you're doing and the organisations you're advising? Workplace health and safety, the look forward, being proactive, trying to get ahead of the events versus, say, HR that may be more responsible for some of those social risks that are reacting to an event. How do you find that inside corporate Australia at the moment and how that's working?
Very challenging. In some areas, those areas are working really well together. But in my opinion and experience, they're few and far between. Because each of those areas, HR and WHS, for instance, are very good at what they do, that's their focus, and they've lent their whole careers to those areas. That's what they focus on. So when you bring them together, they actually rub up against each other. Unless you've got really good leaders in those areas or above them that they're reporting to, who are requiring them to really work together well and for their different purposes, because they've got different purposes to exist and they've got different outcomes to report on. But in this area, they have to work together to share information and to also contribute to each other's area. Risk manage, so HR contributing to the risk management process and work health and safety contributing to the response as well. It's challenging and it's, for me, it's a leadership issue. So the executives, the board also for guidance, but more the executive leadership team, the decisions that they make. I mean, they cannot exercise due diligence, which is the law for them, unless they're getting the proper and good reporting back from their reports, their senior managers. And if those senior managers aren't sharing and working together, they're not going to get good reporting back. So therefore, they can't exercise due diligence. For me, it's a focus on those executive leaders to make sure that those two areas and others are working together well to manage this risk. Otherwise, it's not going to work.
And there's been changes, Tony, right, to the workplace health and safety regulations. Can you perhaps just give us a snapshot of those changes, what's happened and how that you think has impacted perhaps some of these dynamics as well?
Yeah, in the context of psychosocial risk. So the first thing to say is that the work health and safety laws are separate in each state and territory. And the Commonwealth have their own laws for the Defence and Commonwealth employees. They don't all have to do the same thing. Every jurisdiction bar for Victoria have adopted the harmonised work health and safety laws, which is Safe Work Australia put out there for them to adopt, and all of them have it except Victoria, and Victoria still operates under the OH&S Act of 2004. Having said that, there's a fact that the safety regulators could have been prosecuting for failing to manage psychosocial risk back in the 80s when I was a work cover lawyer there back in the late 90s. We could have used the 1983 OH&S Act back then, but no one ever did. Everyone was focused on the physical risk. What has happened is that the regulators and the legislature in each of the states have introduced regulations for psychosocial risk management to make it very clear to all employers and industries that this is a risk that they're going to focus on, that they will investigate and will prosecute for. So the updates to the regulations have really been around These are the psychosocial hazards. You need to do a risk assessment. You need to consider the hierarchy of controls. There's codes of practice to provide a bit more guidance on that. New South Wales has introduced the fact that if you fail to abide by a code of practice, that's a criminal offence now. So that's fairly new. Each of them are doing some different things, but what is clear, what they're all doing, is they're all saying to employees around Australia, this is a work health and safety hazard and risk that we are now focused on strategically, and we're going to investigate and prosecute for it. So they're making that very clear. There's been other updates, like everyone now has the manslaughter, the work health and safety manslaughter offence, very political after a number of deaths of young people at the workplace, mainly construction. And there's been a few other little things, but they're the main ones.
Yeah, and certainly obviously don't know it as in depth as yourself, but I've looked at that law in recent times, and it is more prescriptive, isn't it? These regulations that you're referring to here to try and, I suppose, help with guidance. But in terms of
Exactly.
practical implementation, I would think that there is still quite a long way to go, right? Because it's sort of a recent flavour of the month thing, isn't it? Psychosocial
There is a
well-being.
long way to go. In fact, I've created a maturity model for work health and safety, which I'll see if I can bring up here for you as we're talking. I can find it for you. This here is what I have called the psychosocial risk maturity model. And in response to your question about where the market's at, David, let me just say that some of the listeners may have heard of the Hudson Safety Maturity Model, which probably goes back into the 90s when Professor Hudson created a maturity model for work health and safety implementation of systems. I've taken that model and put the psychosocial risk management into it and created this maturity model. And you can see from the very left, from a disassociated way of being for a business, right through to the very right hand, a dynamic risk management of psychosocial risk. To your question, I've not seen any organisation, government or private, ASX listed or small, be in a dynamic, very right-hand side. No one is managing this risk systematically at the moment. And I think that's because, as you said, that whilst it's not new, it's newish, and a lot of people are still trying to catch up. Plus, people can't implement it overnight. For a larger organisation, it will take 3 to 5 years to fully implement. What I found is that the good organisations, the ones that have done their risk assessments, the ones that have consulted, the ones that have used the hierarchy of controls and are up to implementing and maintaining and starting to report on those controls, they're in about the learning area in the middle, moving into activated. One of those two, learning to activated. The best ones are in activated, and there are some probably SMEs still down in disassociated, down to the very left, and there's a lot of people still in the reactive, which indicates there's a lot of work to do when it comes to the implementation of systems. As you intimate, it's not good enough to create a safety system or a policy and procedure. You've got to implement it, you've got to use it, you've got to improve it and make sure it's working. And that's the key. If people are going to be prosecuted for this risk, it'll be for not implementing, measuring, monitoring, maintaining the safety systems to manage the risk.
Can you just pause it for a moment, please? Just gonna deal with my dog.
No problems, David.
To note to cut at this portion.
How's it going, Nolan? Is it flowing okay for you?
Yeah, it's very interesting. I've always enjoyed the whistleblowing segments because I don't usually hear these conversations except from David.
Yeah,
It's really
very
not something
good.
that you hear on a day-to-day basis.
Yeah, very good. I'll ask David when he comes back if I should stop sharing or if he wants to keep it up there.
Yeah.
We couldn't hear the barking, David.
Oh,
So
you couldn't.
no, we couldn't.
I think your
No,
dog has some whistleblowing to tell you about.
yeah, might be trying to make a complaint.
Yeah.
Only barks in a way that I can hear. Eh?
Well, you investigated, so you can put it to bed now. Do you
Yeah.
want me to leave this up for a moment, or
Yeah,
did you
yeah,
want to?
please. Yeah,
Yeah,
yeah. I
I
do, I
will.
do want to ask a couple of questions. So, um, are we back on yet or?
Okay, on the count of three. Three, two, one, continue.
Yeah, Tony, really interesting this maturity model that you've presented here. Is there any differences between size of business in terms of the requirements here and what the expectations are of organisations in Australia?
Great question. The short answer is no. The requirements to proactively manage this health and safety risk is the same.
Right.
However, the safety regulators and the courts need to take into consideration the size and time, cost, and resources an organisation has to manage the risk. In other words, when it comes to the controls, a particular small business or a medium-sized business that doesn't have the resources or the time or the costs may put in a lesser control because they simply can't afford the bigger control the big business can, and doesn't have the support like HR, WHS, support behind it. So to answer the question bluntly, they've all got the same obligations, but certainly anyone judging an employer about whether or not they're proactively managing this risk must stand in their shoes, given the time, costs, and resources they have.
Yeah, that makes complete sense. So, within the control hierarchy, we know that there's a range of different types of process and control mechanisms.
Yes.
And yes, the policy is sort of at one end of the spectrum, the drafting of a policy. I was listening to, not listening, I was talking to somebody in a super fund a couple of weeks ago, 750 person business, heavily
Mm.
regulated industry. And
Mm.
she was describing to me the work that was going into their psychosocial enterprise risk management sort of framework, and it was significant
Yes.
to sort of implement, and the stakeholder engagement piece, the volume of work involved by leadership to put that in place. Even she did describe there was some fatigue, from the organisation and from
Sure.
staff in
Yeah.
particular around the volume of governance, that they were sort of implementing in relation to this.
Definitely. Look, what I find and have found is that blue collar industries and employers are much more understanding because they've proactively been managing physical risk. So they know risk management, they know the hierarchy of controls, they know what they ought to be doing. Yet for many of them, this is still new. It's a new way of thinking, and they need to think outside of the square and the box to be able to consider all these hazards. But for white collar industries, really, this is the first time that many have taken work health and safety seriously. It's the first time that it's really properly got to the board in such a way that the board are concerned, and the officers of the board, of this risk, to the extent where it's up there as one of the highest risks that they know they need to be managing otherwise. And it's not just for the criminal fact that they could be convicted if they're failing to manage it. It's because it impacts productivity. It impacts the culture of the business. There's so many good business reasons to get it right. And boards know this. And suddenly they've got a proactive risk management lens and a safety lens on this now. Whereas before that, work health and safety was a paper cut or manual handling or minor things. It's much bigger than that now.
Yeah, and when I think about sort of what you're saying and looking at this diagram, and then we overlay, the whistleblower management system with this model, this maturity model, and then you break the whistleblower management system down into processes and controls. There's a number of things there whether it is the whistleblower policy explaining how you raise a concern, whether it's the
Mm.
third-party whistleblower technology system that is enabling you to speak up securely, whether it is your grievance policy that's giving you guidelines how to raise a problem that you've got with another worker inside the workplace. Whether it's a board report that captures the different types of issues or complaints that have been raised, across the organisation for the board to dissect and determine, is there any strategic problems here, from a conduct or
Yeah.
culture perspective that we need to be dealing with.
Yeah.
A number of aspects of whistleblowing that, again, interconnects with this model and some of the language and sort of information you're sharing here. It's really, really interesting.
Great. Yeah, well, they're my recommendations, I suppose, to leaders. And
Yeah.
this is a real leadership issue. And it is one where the courts expect that you be proactive to manage the risk, not reactive. And so therefore it focuses one's mind on what reporting, if you're an officer, if you're on the executive leadership team, if you're on the board, what you should be asking for. And my recommendation is, once you've done your risk assessments, once you've agreed on the controls in consultation with your workforce, measure how the effectiveness of those controls are going, because they won't always be effective, and they won't always be effective in every part of your business. And expect some reporting back to the board that indicates where it's failing, where it's not working, so that you can exercise the due diligence and make decisions to fix up the areas where it needs improvement. And that is due diligence. If I'm a board member or an executive, I'd be very concerned if all the reports were coming back green lights that everything's fine, because that's never the case in reality. And so boards need to get used to seeing some not so good news in these reports, together with some suggestions from their management about how to improve, and then make decisions. Maybe they might need to do a bit more investigating or a bit more inquiry, but then be prepared to make decisions to channel time, cost and resources to fix an area before it becomes an issue for them.
Yeah, well, it certainly sounds that way. If regulators are, this is a priority area for them now, and this increased regulation that's coming, through, the legal world in recent years, is driving, that appetite as well. So that certainly puts, I think, a lot of companies on notice, and it's very sort of useful and timely, I think, to be having this discussion with you. I mean, how are we sort of placed, Tony, compared to perhaps other countries around the world?
Yeah,
in the psychosocial risk space?
we're near the front, and we are leading in some areas. I know that even the UK are watching what we're doing, but there are in Europe, in areas, pockets of Europe, it's very good. UK is onto it, probably not as much as we had been to date, but and everyone is being prepared to share and learn from each other, because there's some good things happening in the different areas. Certainly our legislature has been onto it, and if we ask why, I think it largely comes about from the issues that experienced about 5 years ago in mining, particularly in WA, and with respect to sexual harassment, and the issues there really started putting the pressure on the regulators to do more to prosecute for failing to manage this risk. And that, from mining, it extended out into all industries and to all of the safety regulators' expectations of the community that they all need to do better, which then put pressure on the employers to do better. So yeah, I'd say Australia's leading in some areas, and other countries are watching, and some are adopting, and some are doing their own, and in pockets, probably arguably doing better than us in some pockets.
Yeah, it's really interesting, because it's not too dissimilar in sort of that whistleblowing world of ours as well. The changes and the strengthening of the Corporations Act in 2019 was seen as a piece of law that was a lot stronger than many other jurisdictions around the world, and I think one of the challenges in Australia is, of course, the state, federal, local government system and how that can
Yeah.
complicate the sort of regulatory frameworks and make it quite opaque for people to work their way through all those, multiple different systems. But actually, when you drill into the level of protections and the breadth of protections and how they have sort of evolved in the last sort of 5 to 8 years here, that there's a lot more progress in Australia than there has been in other similar sort of countries.
Yeah, and you raise a thing there that brings to mind that some people may argue we're a complex system with our states and territories and various jurisdictions, but the fact is, when it comes to any organisation proactively managing this risk, the systems are the same. You manage this risk the same way in every state or jurisdiction in Australia. It doesn't matter. So even though the laws might have nuances, the requirements are the same, basically. And so if you have systems that proactively manage the risk, you comply with all of the states and territories, because some of our clients, of course, they're in each state and territory. And maybe they're even working with a Commonwealth entity. Doesn't mean they're under that jurisdiction, but still they're a contractor under the laws of the Commonwealth. They don't need to worry about all the laws. They just need to make sure their safety management system is correct in managing these risks, these foreseeable risks, and this is one of them. So what I say to leaders is don't worry about the nuances, and that's for your lawyers to think about. It's more about getting this system right, getting it implemented, measured, monitored, maintained, and that's the key here.
Yeah, no, look, great. I think great final words. I think I might wrap it up there, Tony, because I think how you sort of summarise that, and we've got a very strong view on this as well, and it's very aligned with what you've just said. The whistleblower system, the technology that should be part of that, it is actually around implementation, how it's designed, and making it fit for purpose for organisations. The law itself and the protection of whistleblowers under the law is a very small piece of the jigsaw puzzle when it comes to a best practice whistleblower management system. And so I think I'll leave it on that note. But I just wanted to thank you very much for coming on. I've absolutely, I've really enjoyed the discussion, really enjoyed what you've had to say and the expertise you've shared with us and our clients here at Verimark. So thank you for coming on. And we look forward to hopefully having you on here again at some point in the future.
Thanks, David, and thanks very much.